Welcome to Juris Stupidity, a video podcast devoted to legal terms and concepts that are misused or abused in social and regular media. This episode is on the attorney-client privilege. Various talking heads have suggested that the attorney-client privilege is somehow at risk and has been violated in some high-profile cases. Without getting into those details, I'll talk about it today. But in fact, however, the attorney-client privilege has been acknowledged as being the oldest privilege in American common law to protect client communications. There are, of course, exceptions to the privilege, which we will get to in a future podcast. But there are no, and I mean no, serious challenges against the common law privilege. Any assertion that the attorney-client privilege is at legal risk plainly misstates the doctrine and the concept. But first, we should address this. What is the attorney-client privilege? It is a privilege that allows a client and requires the client's attorney to protect communications made in confidence that are, 1, related to legal advice sought from a lawyer, and 2, within the lawyer's professional capacity. It does not protect communications between the client and the attorney that are either, 1, in the presence of a third party, or 2, when the client reports the substance of the communication to a third party, or 3, when the client voluntarily provides documents or other records of the communications, such as tapes or recordings, to a third party. It does not protect from disclosure that there was a communication or the nature of the communication. As you can discern, the privilege is very narrow to the very communication itself. Merely having a conversation with an attorney does not make the conversation subject to the attorney-client privilege. The client and the attorney must have a professional relationship. Otherwise, it is not an attorney-client privilege. However, keep in mind that an attorney-client privilege can exist without an attorney being retained or even paid. For example, an attorney offering a free consultation can create the attorney-client relationship when giving advice in such a consultation, even though money does not change hands. The same principle holds when attorneys provide pro bono work that is done for free for the public good. In all, the attorney-client privilege is alive and well in American jurisprudence, no matter what some ignorant talking heads say to the contrary.